All right, the commission is back in session, and we're actually going to start with the executive director's report, and then we'll go back into our facilitated discussion.
Thank you, Madam Chair. Four quick but important notes. One is on the budget. As we discussed last time, we are in the process of finalizing our budget change items. We did have 4 budget change items this year. Maintain current service levels, comprehensively review the sentencing guidelines phase 2, staff's agency administrative support needs, and modernize and take fiscal responsibility for the electronic worksheet system. Regarding the comprehensive review, if we are to conclude the comprehensive review in the next biennium, the commission will need to finalize its policy choices and send them to the contract rule writer in mid-2026, which is much closer than it seems. Second point is on rulemaking and the 2025 calendar. So we are currently in the process of changing our administrative rules. The first draft of the proposed changes is out for public comment right now. And the revisor's office is looking at that first draft and looking at possible changes to those. It seems unlikely in conferring with the revisor's office that we will have new rules before next year. It could be well into next year that we have those new rules. So since we're in the fourth quarter of 2024, I thought it was prudent to send out both to you and to the public the standard 2025 meeting calendar. That's according to the formula that the commission has previously adopted. So it should be pretty familiar to you. And then when the rules are adopted, if they are adopted in a timely manner in 2025, perhaps the commission might be interested in changing, simplifying the 2025 meeting calendar at that time, but that'll be a future decision. The third comment has to do with Hennepin County. MSGC staff members have been talking with Hennepin County judicial and probation leaders about using 2 tools built into the electronic worksheet system, pre-plea worksheets and the criminal history summaries, in an effort to increase compliance with the requirement to have the guidelines worksheet at sentencing and to decrease sentencing errors. We are very encouraged to report Hennepin County is very receptive to widespread adoption of these tools, and I want to give a shout out to Linda and our staff who's been spearheading that, and to Latanya who made the necessary introductions into Hennepin County. We really appreciate your help there. The fourth item is a little bit dated at this point. It has to do with NASC, the National Association of Sentencing Commissions annual conference, which was held in Raleigh, North Carolina. We had several staff members. In addition, we were able, well, nearly all of last year's, I'll call them freshman class, was able to, the commission members who joined us in 2023 were able to attend this year's NASC conference in Raleigh, North Carolina. Sorry, Chief. Although many of those were funded by sources outside of the agency. So feel free to ask any of those members about their experiences at the NASC conference. The chair was also there during a break. Then that concludes my report, Madam Chair.
I think we're going to get another break.
Oh, yeah.
Yep.
I don't know. At this point, it's up to Charlie and then Shamsa. So.
Yeah, it is. So I do want to turn it over to Charlie and Shamsa, and I actually do want to turn over the break power to you as well. So whenever it makes sense for us to do the afternoon break, that's when please go ahead and call it.
Great.
But otherwise, please take over.
Thank you, Chair Mitchell. So we are back to continue the conversation we started this morning around what we are learning from different audiences. And so this afternoon, we are kind of narrowing in. I kind of see the morning as we put a lot of stuff on the table and kind of we're listening to a lot of information. And now we're trying to narrow in on what is in common, what is in tension, and where do you want to go as a result in terms of future follow-up engagement and follow-up research. So the first step this afternoon is we're going to share from our work what we saw in the engagement as general themes and general tensions. And then we're going to turn it to you all to continue that conversation and identify for you what themes and tensions you are seeing as well. So the first part will be a lot of us talking, and then we will turn it back to you. So just as a kind of a more background, so remember that we will be using this conversation to determine what areas you are committed to exploring in the future. So we will, again, first share what we've seen, talk about what you've seen, narrow in on what challenges or areas you want to address, and then talk about the methods of how do we go do follow-up engagement? What questions do you have for the research team? All right, so I'm going to share out a number of themes that we saw. So we, on the MAD side, identified some common themes and some common tensions that we wanted to share back with you today. So I'll start with the first one, and then Shamsa and I will kind of alternate between them. So the theme number one that we saw was simplicity. There was an appreciation for the simplicity of the guidelines as a framework and frustration that they have grown too complex, especially in the examples that you all talked about a little bit earlier in terms of out-of-state offenses, the criminal history scores, and the departure rules.
The second theme, all right, so the second theme that we also noticed in our sessions is that while there were differences on appropriate sentences in terms of relative severity, drug and property crimes were generally seen as less severe than person crimes, particularly violent crimes and sex offenses.
The third theme we saw was that there was frustration that probation, kind of as currently implemented, is inadequate for preventing recidivism or for promoting rehabilitation, in part because of understaffing and insufficient access to treatment services. And you mentioned kind of geographic disparities there. And in turn, that creates new challenges in maintaining compliance with supervision.
The fourth theme that we also noticed is that comprehensive ongoing training on the sentencing guidelines for practitioners, particularly for probation officers, attorneys, and judges, could reduce errors and inconsistencies in applying the guidelines.
The fifth theme that we heard was that geographic, racial, economic, and educational disparities continue to shape sentencing, leading to inequitable outcomes.
And then sixth theme is frustration that victim input seems to have little influence on sentencing at either the system or individual level.
So I'll just step back and share this. This is one slide with all of that, of those six themes that were kind of in common, or at least were widespread. So these did not necessarily appear in every audience group, but they were common across several, and we wanted to elevate as things that we noticed across. So we'll turn to tensions and then we'll expand the conversation. So go ahead.
Yeah, I'll start. So tension number one, purposes of incarceration and probation. There are different concepts for the purposes of incarceration and probation, or there's a confusion of what is the purpose of incarceration and probation that we're hearing from sessions.
Tension number two was the effectiveness of incarceration. So there was both skepticism on the effectiveness of incarceration and meeting whatever those purposes are, but also skepticism of the alternatives, whether there was anything else that would be effective either.
Some felt that punitive measures should be strictly enforced to ensure accountability and public safety, while others believe that true accountability and public safety can only be achieved through restorative practices rather than traditional punishments. So this is a tension that we're also noticing that we also want you all to start discussing.
The fourth tension that we noticed was around consistency, and we heard you mention this as well, that there was a shared appreciation for consistency, but there were also differences in how the system might achieve that, either by aligning presumptive sentences to meet departure practices or by narrowing the ability for downward departures. And then more conceptually, this consistency tension of consistency being valued at the system level alongside an interest in consideration of individual circumstances. And I think Commissioner Orkin, you kind of pointed out those are kind of in tension with one another, but people were expressing kind of both desires of wanting a system that was uniform and consistent, but also wanting the ability to have individual consideration for individual circumstances.
All right, so tension five, different visions for departures, either as a tool to address lack of blameworthiness or to address amenability to rehabilitation. For example, unemployment or substance use disorder might both reduce blameworthiness and reduce amenability to rehabilitation. That was a mouthful.
Yeah, so in our sessions, things like unemployment and substance use came up as reasons, in some cases, we were hearing for for example, if someone was unemployed, we could have understood why that may have led them to burglary. But in the system, that's not how we necessarily treat unemployment. And so there was that tension of is a departure about blame or is it about the ability to probation?
And also piggybacking off of the conversation or the presentation we had this morning with the Rabin Institute and that new system. Connecting the dots here.
And then the final tension we wanted to highlight was sort of general versus technical feedback. So a specific example of that was no contact orders. So in our public defense sessions, there was this idea raised that no contact order offenses were being treated too harshly due in part to how they were applied and like the scope of their application technically. Whereas in the crime victim and in the formerly incarcerated audiences, there was a expression that domestic abuse cases, such as the example that we gave in our sessions, need to be treated more seriously by the system in relation to the other offenses that they saw. So there was sort of a, like the public was giving us really broad feedback about the importance and severity of certain things, and then we were also getting more technical feedback of application from practitioners. So this again kind of steps back and shares all of those general tensions that we saw. And again, some of those were tensions between different audience groups, but there was also tension within audience groups or within individuals, again, that idea, for example, of wanting consistency, but also wanting the ability to consider individual circumstances. So they weren't necessarily tensions between different people or different audiences, but just kind of tensions that people were grappling with as they were answering our questions.
So we want to turn this question to you all. The question we had you all ruminating on before lunch: what patterns or themes stand out to you from all presentations this morning and from earlier research presentations? So I want you all to consider all the resources of information, including our information, as well as the University of Minnesota Rabin Institute, as well as the feedback we heard from the judicial branch.
So in this first piece, I think it's about 10 minutes we have. So just in our table. So we're taking advantage of the setup we have today to kind of start the conversation at your table, and then we will have a round robin where we actually will ask everyone to weigh in, and we'll take some collective notes. But wanted to start the conversation at your tables. But what patterns or themes stand out to you?
Don't be shy.
Yeah, I know it's a little bit non-traditional to have you each talking over each other, but let's give it a try and see how it goes. So yeah, at your tables, talk about what patterns or themes stand out to you.
Well, it seems like we have not too hard and not too easy. So,
Mr. Warren has
and it was the energy department was powerful.
an empty spot.
Alternatives. And other areas we're thinking about, but what is going
Okay, so
their sentencing, so I can really get that across multiple. There's a focus on victims for most part, and the majority of them. But I think there's an issue when it comes to in terms of so focused on guidelines. I don't know how much doesn't really say the criteria or just focus on guidelines. Or is the departure the reason because of what they're going to be doing? What is deal with
There's a worksheet.
Yes. They don't ever see it say because of it.
I only have one of our and that's like, yeah.
Which is.
Yes.
Yeah,
Like the goal is.
And I think that's a good intention. I feel like that. Just as I was.
I wonder, sometimes I've got a failure.
So I think the idea that we try to contact other.
It is a good concept. But the town guidelines.
It is.
Well, that's interesting to me because it's all of us in the firm don't even understand how they, and I think that's to me is very clear.
Priorities.
Like that, there's no other way it's.
I get it, but
Or you don't care about much. One mitigating things going on in my life. This is a one-off. I've never seen stress. Oh, you don't care what we're doing, we're trying to. I wonder if
That's their discussion.
says, what about immutability? That's hard to determine. I don't know what how many of those are going back to the Right. I mean, I haven't known PSI. I only do PSI on my own clients. I don't do PSI on friends. I know, especially Rick, he's like, years ago, is taking some notes on all this for a probation officer. But I don't know if we really
Again, just like one person reading it, does a straight investigation. That's all rules. Rights, all this. How many relational people are
The reality is.
doing that thing and that's huge.
This is a very.
You know, like, there's just so much such, almost overwhelming. Looking at all of this, there's not one
I
little.
mean, it is.
Oh, yeah.
always trips me up. Where you're saying, and so the law enforcement, they said sob story. Sob
Yeah.
story.
Yeah, because that's all they see. They don't understand the whole system. They just hear this. Oh,
I would guess that the harsher rates, you know.
You missed that pretty yeah.
It's not just be off the charts.
That thing
Every
is,
defense lawyer.
Was it 2001, 2022? Yeah.
community has thought.
And there are.
And I get it.
So, like, I wonder if. Yeah,
It goes to the sense, that's,
He's out here.
you know, we can pull out
Okay.
horror stories.
But, I would invite you to see more videos on
So that if you give us that,
that's how it is. No,
or with the
what
release date.
they want to see for children. Explosion right now.
yeah.
Look at that, that's what, that's too tedious.
Full board to stop it.
Skyrocket.
So that's the unclear.
That's what I'm trying to negotiate.
Hands that we-
I had a one-off after last week's meeting.
Yeah, so now we've
You
got.
never get the data.
But I don't think
So,
To be constituted.
because I have.
really succeed.
With the circuit found Judge Frank.
Full board is supposed to risk.
So I.
Emotional, it's one or two cases.
can-
So what is
But
it?
it's tough as.
What
I mean, yeah.
You know, there are.
Lurchers are also put in seriously. In the city. It's not. But it's. Are now. Yeah, they said, what's this? You'll do related.
There's been a lot of.
Yeah.
Like, I think the other side of it is that. Actually.
Yes.
Yeah, might
This is how commission is,
Let's use it.
if they
Properly
just-
set out.
getting there, I just.
the backlash of the violation.
Yeah.
That's why we wanted to change the drop off of that stuff.
Yeah.
Right, for the time.
Yeah, I think that's
Yeah.
see what it's like.
Where one judge.
They don't.
Or one type of crime. And so they simply operate.
The thing about certain people, higher or lower, kind of like so higher or lower in terms of severity.
Yeah.
That was kind of a thing too. They used against. They also mentioned speeding or homicide, which is. There's been a comment
On the table by law.
because it's 4 years. It's being near double or triple for a drug case. And then the case over south now has some news going to trial.
Fire false arrest. Yeah, so.
Like that was political, but I have a family member that was murdered by a parole for drug.
Yeah.
He's been homicides, a couple of years, now, horrible. And so,
They found that
there's
the air.
inequities.
There was actually.
That's why the nice.
Like,
Yeah, should be different, because now, why didn't you charge? Why
They
didn't
were
you
still
do
getting.
why is all this thing? So I
They
think
were
we
still
should
getting.
cross these
false-
All right, one more minute.
areas, they want to make sure it's fair. They want to make sure that there's some semblance of justice. I didn't hear anyone say they wanted to be overly crazy, like every day, which was good.
And we have control boards have trouble even if they're given good risk.
That would also.
And then it's because it's not risky, and so people.
There's no incentive when you have the question.
Yeah.
Counselors.
And there's a lot of.
Well, because we're always thinking.
Right.
I often hear, well, how come when you
Scary
go
story.
home, the wife goes, the other thing that's always nice to always say, things happen.
All right, let's wrap up at our tables and we'll come back.
Yeah.
No announcement for it.
Right. Right, it's their
So
person.
that's an
All right, I'm gonna bring us back together to do a group round robin of just each sharing one pattern, theme, or tension that you wanna collectively put on the notes. I will try to write down on these easels, kind of a summary of what you're saying, but please tell me if I'm getting the words wrong. Help me kind of record the core idea you wanna share. So, Chair Mitchell, is it okay if we start with you? And then we'll kind of go around at the tables and kind of, we can do a second round too, if people have more they want to share, but let's start with like one pattern, theme, or tension you want to elevate for the group.
All right, I'll do the big one. So one of the last things we just talked about was this desire for simplicity. Yes, it was there, and in your themes. But we were like, there's a lot of rules that are around trying to make things uber fair. Like the misdemeanor rule is extremely complicated about how you do that. So like maybe in some ways, what if we took out misdemeanors, juveniles, custody status, and like what would the impact actually be if we took a lot of that stuff out and made it simpler and more streamlined?
Thank you.
You want a popcorn?
Let's just,
Oh,
yeah,
actually,
let's make sure we make sure everyone gets a chance though. So let's actually just do it by table if that's okay. And then, so at this table, let's make sure everyone gets a chance. And then we'll.
Oh, you guys get to.
Yeah, so
We each get to.
yeah, you each get one. Everyone gets one. You want to get to everyone. Oh, yeah. So every individual gets one.
Just make it.
We're gonna go table by table.
So I think one of the tensions that we talked about that seemed to come out across there was the kind of the tension about who the particular group is, in a sense, I guess, representing. So we seem to have a tension between, what's best for victims, how much victim input is there, and how the focus is there versus on the defendant. And that tension seems to be really divided among the groups not hugely, but it's definitely there. And it seems that we have to look at both and what's best for both. So that was one of the tensions that we talked about a bit. And Chair Mitchell brought up a situation particularly like housing. And, there's always a tension there about the housing for, I guess you probably put it best with the domestic abuse victims versus individuals coming out of prison. They also need, they both need housing, but nobody really thinks about, they're completely different. But that's maybe just one example.
Thanks.
Another thing we talked about is the tension between wanting the guidelines to be very specific and cover all eventualities, and then also, on the other hand, wanting there to be broad discretion to cover case-specific details. And we talked about how we might be able to resolve that tension by mentioning more factors that should be considered, but not necessarily telling the court and the parties how much weight to give to each factor that's referenced in the guidelines.
Thank you. Which table wants to?
Oh, you give them a choice?
Well, go ahead with table
So
over there. You all over here.
We'll go.
Yeah, go ahead.
I'll just throw one as, that we feel like any inconsistencies can sort of equal in whichever party's mind, inequalities. Whether it's law enforcement doesn't feel as if, those convicted are getting their just desserts, and victims don't feel like they're being represented. And then the case where two individuals convicted in the same cell with different, durations on their sentence feel inequality there also.
Thanks.
A lot of the things raise sort of the general problem of striking a balance and finding a Goldilocks point and communicating that. So on the issue of our victims heard, or do their views affect the outcome? There might be a communication problem that this isn't a civil case. This is a public case of the people versus the offender, and your employee is of interest, but it's not going to determine the outcome in most cases.
And I would say equitable accountability was kind of simplified. Was a thing that I saw over the groups.
Thanks. Yeah.
I don't know, I just am not concerned about the tension. The tensions are there because we're responding to the public. Those are the demands that the public is putting and placing on our system. I think the greater the tension, the better the decision. That's when we're going to achieve justice. Because we're not going to eliminate one side of the equation on any of these tensions. It's always going to be there. built in, baked in, because we've got competing demands of what people want out of this system. So the question is how to balance and measure the tensions in each case to achieve justice.
And when you say what
I think
people,
the tensions are healthy.
when you say what people want, who are these people?
Who are these people?
Yeah, I'm talking about,
It's the elected official that's prosecuting the case, it's the victim who suffered a loss, it's the defendant that we're trying to rehabilitate and prevent from committing this act again. It's the message we're trying to send to the public, this is not acceptable behavior. Everybody, it's the entire community, it's all those needs and interests. So if we want to eliminate the tension, I think that's a mistake. One other thing that I talked with our group about, we had this opportunity to get a lot of feedback from a lot of people, a lot of interest groups, and we got a lot of good feedback about procedure, process, some changes, some modifications, and not necessarily overall public policy, these detention issues or all of that. So I guess I would like to see us compile all of those issues about, looking at re-ranking some of the offenses, looking at rewriting and organizing the commentary around maybe cases or offenses or person or property, so we can find information and it's a more user-friendly commentary. There's a lot of things that don't necessarily involve or relate to a revision of the guidelines, but to make it more helpful. One thing I don't think I mentioned, it came up twice in our judge feedback, they want a portal. What are we talking about? They want some way you can just, we can find out what the criminal history is right now and we can just type it in and we can get it. And it's got all the updated information, it's got all the current, and everybody has access to it, so we're not making these mistakes on criminal history or decaying of criminal history, that kind of thing.
Thanks. Others at that table?
Can I just say ditto?
We didn't know we all had to take a slide. We thought we were collecting.
Okay, so
It's a joint
same.
What
else?
Okay, we didn't get a chance to talk about this because we were having such a robust discussion, but as I think about, like, one of the slides you talked about, in attention, which I agree with Judge Knudsen about, I think tension is baked into our system by virtue of various stakeholders, and those are our roles, and that's how we check and balance it. But when we talk about the purpose of, like, incarceration and probation, we focus a lot on treatment. One of the things, and I say this not as criticism because I wasn't on the commission at the time, but as a practitioner, I asked the question, like, what were they thinking? Like, when they redid the grids with different grids and they did the drug crimes, why was it separated out between the possessions and the sales? Because one of the things that I look at from a practitioner is when we talk about treatment, there's people who are charged with possession crimes and they're addicts and they're possessing because they're addicts. And then there are two people that are engaged in the enterprise of selling very serious and dangerous controlled substances. I don't know why we're treating them the same. And when I sit in court and I hear a defendant who's charged with a sales crime and he's asking the court for a departure because he wants to go to treatment, I don't know what treatment he's going to go to for his drug sales. And I feel like that really diminishes the need for treatment for people who are addicts and need treatment and want to go to treatment, as opposed to using that as a tool to get out of a consequence or being a drug dealer. And so in terms of that particular grid, the idea that maybe we should have some separation between that conduct, because there is different accountability. And if we're going to really look at treatment tied to the kind of crimes that are charged, I think it's hard to do when they're all kind of lumped together.
Thanks.
anyone else on that table?
All right, Commissioner Larkin.
Well, my table was very agreeable. I think it's clear we need, well, I think it's clear people would like us to reassess some of the current severity level rankings to make sure they accurately reflect conduct that we think should lead to imprisonment as opposed to probation. So I think that's important. The call for simplicity, loud and clear, I think the chair is right. When it comes to simplifying, I think we have to look at the criminal history score and custody status. As to criminal history score, I think we have to consider whether we want to be dealing with misdemeanors. Maybe we only want to use gross misdemeanors, because even for targeted offenses, if you're a repeat offender, you're going to get from a misdemeanor to a gross misdemeanor soon enough. It's not as if we're going to miss somebody who should be in prison because we're not including a quarter-point misdemeanor in their criminal history score. I also think we need to take a look at whether we should be including juvenile delinquency adjudications in an adult criminal history score. That seems unsupported for a number of reasons. That's different than an EJJ. If it's an EJJ conviction, that counts as an adult criminal conviction, that should be in there. So those are the three things that come to mind for criminal history score. Regarding custody status, I think, we're at the point where we just have to say in or out. One of the comments, or I think a couple of comments, is where, it's 3 months. What's the point of this? There is some merit, and I understand, and I've been opposed to eliminating it altogether because I completely understand everyone's thinking that, you're on probation and you reoffended. Obviously, you're not getting the message, but there might be other ways to deliver the message. And, when I throw out, okay, these are things we can consider, I think they need to be balanced with. Then there are some other things we need to jack up, consistent with what the public has asked for and consistent with what we've heard from everybody, which is there are some crimes that are so serious, you go to prison. And I think the public might have more of an appetite for, well, you're taking out the custody point, you're taking out misdemeanors. If in fact they knew that we were going to target those offenses, which we all agree should result in incarceration, and there weren't going to be departures on those offenses. So I think it has to be a balance. You just can't come in and say, we're going to do all this to reduce criminal history score, but we're not going to do anything else to really target the people who haven't gotten the message. And then I think I like the idea of increasing ranges in the box, but I understand, I think that's a statutory issue. They've told us what our permissible top and bottom ranges are. I think the guidelines statute itself does that. But I do think that's something to talk about because it is a way to allow for some discretion within defined parameters. And I mean, you can look at people similarly situated and say, well, you each face this range, but your individual circumstances, which distinguish you from somebody else, justify where you fall in that range without having to go through substantial and compelling circumstances, which is a much harder finding to make. So I think that's sort of an idea that might give a little more discretion that allows for individual circumstances, but might require a statutory change. Finally, I think we need to eliminate departures. There are far too many downward departures for us to say we have a sentencing guidelines system that ensures consistency from offender to offender. So, I think the way you do that is not necessarily saying, well, let's just lower all the presumptive sentences because then we'll be hearing the same arguments about they're too high. I think we need to really target those offenses where the sentences are high intentionally and be willing to do that and figure out those offenses where, okay, maybe these are ranked too high, they'll come down, maybe that eliminates some departures. But, there's not going to be room to do that for guns and gun offenses. And there are mandatory minimum sentences we have to consider where the legislature has given us clear messages that you don't have authority to depart even if you want to. So we have to consider that. So those are the thoughts from my table. I think if we can do something about the departures, we're going to hit a lot of the concerns about geographic differences.
I actually do have one that I feel like is missing from there. I felt like another theme was, when appropriate, investing in rehabilitative services and like making those mandatory. But I would also say, like really thinking about what successful services look like.
The only thing I'd say is like, there's only so much of that this group can do. I mean, within the sentencing guidelines, we can't mandate service, I mean, and I know we can't do that. There's only so much we can do. I mean, we work with establishing presumptive sentences within a range based on severity ranking and criminal history, which we can tweak. But when it comes to the guidelines saying you must do this or that, I don't know if that's something we can do, because, you know, we kind of went pretty far to talk about, well, probation caps. I don't know that the Sentencing Guidelines Commission can talk about, you know, mandated rehabilitative services. As important as that is, that's just another example of a system component that might be beyond what we can do.
Yeah.
No, exactly. And then one thing, I've just got to say this, because as somebody who was a public defender and a district court judge and now on the Court of Appeals, it's like, be open to the possibility that people aren't being sent to prison willy-nilly for first offenses. I mean, to go to prison, most people don't go for a first offense unless it's a murder. And even for serious offenses, people get opportunities, they get stays of imposition, they get probation, they get multiple opportunities on probation. And then, you know, judges don't like to send somebody to prison. No one does, but you kind of reach the point where that's where the person has taken us. So you can't just assume that, or be worried that people are just being sent to prison too quickly.
And that brings another taking point then is, how many times and chances does someone get in the community and in the community understanding, like from probation perspective? I may have, it takes a lot for me to recommend that. That's like my last, I think someone said nuclear option, I heard that somewhere.
Right. And I think that's
you have to get to that point, but then when you do, community sees it, oh, well, you didn't give enough chances and you didn't do this and you didn't do enough treatment. And how many times do you literally do that? It takes, they have research 8 times that it may take for someone to get treatment, but what if I went to 13? Is that still not good enough for the community to say, at some point, we have to take action? So there's a tension there between what the community think that we're actually doing and what's actually happening on the ground as one that does the work, so.
Thanks, Commissioner Webb.
Can I ask a question based on what Commissioner Markin said?
Yeah.
So, I'm pleading ignorance. What is the statutory constraints or the rule constraints as it relates to what the range is on the guideline grid?
So, and if I could just respond to 2 things that Commissioner Larkin brought up. So first, yes, there is a 15% down, 20% up requirement in statute. So that's, and I will say, my thought, you know, kind of going back to June of 2026, is the thought that while the rule writer is writing up all the rules, the commission could maybe be looking at recommendations to the legislature during that time. While it's waiting for the cake to bake, basically. The other thing I wanted to point out is there is almost a dormant paragraph in the commission's charter statute. So the commission, and this is really from the 1978 statutes, the commission's given a mandate to create guidelines for offenders for whom imprisonment is proper. And then it's given this optional paragraph it may promulgate, establish appropriate sanctions for offenders for whom imprisonment is not proper. And then it goes on to list a lot of things that those kind of guidelines would have to talk about, including fines, day fines, restitution, community work orders, work release programs, and community-based residential, non-residential programs, local incarceration and probation and the conditions thereof. So there is this dormant authority that the commission has. Really, the only thing it's exercised, I would say, in that paragraph, other than having some words that are kind of non-binding, it is the 5-year probation cap that's since been repealed, having been superseded by statute.
This is actually a good segue into what we're going to do soon, which is talk about what's in scope of different bodies. But I want to honor any other kind of themes, questions about themes that people have after we had completed the round robin.
Or any differing opinion?
I wanted to just to hone in on the departure question. I think a theme is that the departures are signals. So I do think that we are being told that there are these signals coming from the community about certain offenses. But I think our research is telling us it's not widespread. It is more concentrated in particular offenses. And so I think trying to address those would be like address them offense by offense rather than like broadly might be a tactic for dealing with that.
I just have one comment to Commissioner Ladd, when you were asking about the drug grid. Just so when they did in 2016 with the Drug Reform Act, the commission actually put forth a different grid that took into account more people being able to go to treatment, because that was a really big focus. But the legislature modified that to what it is now. That's right. Do you remember that, Nate?
Vaguely, yes.
Yeah. Yeah. So we had a little bit more.
Doesn't mean we can't try again. I'm a big fan of just because that's the way we've always done it or done it recently, doesn't mean that's how we have to do it forever.
Final call for any other, I know it's probably impossible to read my handwriting, even if you were close. All right, so where we're going to turn next is to kind of continue narrowing in and narrowing on areas for action. So a little bit of framing. So as we gear up for the next round of follow-up engagement that MAD will do and the research that the U of M will continue to do, we kind of want your direction as we set up that work. So we want to identify what are the areas that you have the most energy in addressing as part of the review, and then get your feedback on how we might learn more about those areas through engagement and through research. So as part of this first identify challenges and areas, we've surfaced some areas and ideas from the work so far. What we're going to do is we're going to share what we have, ask you to add additional ideas. We're going to merge them together, like what's similar, and then we're going to have that conversation about what's in scope. So you may be able to see, maybe not on the wall over there, we put kind of lanes of things that are in the commission's direct scope, things that could be recommendations to the legislature or to other partners, and then things that are kind of fully out of scope. So that's where we're going, but we're going to start with just trying to surface what are the ideas. And you kind of already got there, like we were kind of talking about themes, but some of these themes were really kind of action items. But that's where we're going to turn more explicitly in this next segment. So I will read off some like surface ideas for action based on the research work. So this is our kind of summary of some of the ideas that came out. We also did talk with Julia, one of the U of M colleagues who isn't here today, just to kind of summarize what are some of the kind of themes or areas coming out of the research. So I'll read these and I'll add them to the wall, and then we'll add more. Sure. Yeah.
Julie is watching the meeting online, and if you need to talk to her, or actually,
yeah, if she wants to add any context, feel free.
Yeah. So Julia, if you're listening, you can raise your hand, and if it's okay with the chair, we can let you in.
So I'll read off the ones that we have, and then we welcome additions or modifications. So we have changes to criminal history score, revisiting the purposes and principles, addressing the rising presumptive incarceration rates and the mitigated departures, reducing the number of people on probation, reducing the use of monetary penalties, and decarcerating low-risk offenders. Chuck's going to add some that came out of our engagement work.
All right, so we have simplified guidelines and manual, review relative severity levels, effective use of probation, expand training, review data on disparities, design mechanisms for victim input. And lastly, revisit guidance and procedures for departures. Sorry.
And as you kind of digest those, some just like notes or framing about it. So think of these, there's obviously a lot of overlap between these. So things like simplicity could connect to lots of others or all of the others, right? So they're not mutually exclusive. Instead, these are sort of ways to focus and frame the work ahead of when we go back out and do practitioner and public engagement and there's follow-up research, what is the frame or the focus area of those asks? What are we asking for input on? What are those broad topic categories? So these are what we have so far. So we're going to add some more. So what feels like it's not on the board yet, but should be based on your conversation today, based on the judicial branch input, which we didn't have when we were making these. So what else would we add? Yeah.
Assuming that we don't have this somewhere in our materials, could you read the green ones again? Because I was still taking notes on the blue ones.
Oh, yeah, and we can put on the slides, but we were trying not to make it seem so like final.
Yeah.
So we didn't have it in the plan presentation, but if you exit it, Shamsa, and unhide it,
Exit.
you exit the PowerPoint and then unhide the slide. We do have this slide there, but I'll read these again. So revisit guidance and procedures for departures, design mechanisms for victim input, review relative severity levels, simplify the guidelines and manual, effective use of information.
Okay, I'm sorry, say again.
Effective use of information. Expand training and review data on disparities. And so yeah, we have these here. So these are the ones based on engagement. And we have a similar slide based on the research. So the question to the group is, what would you add? Like what other kind of areas have you not, do you not see listed there, but that have kind of come out of your conversation or come out of the initial input?
I think just dealing with unranked offenses. Everyone wants us to deal with that.
Thank you.
That's number one.
I think we need to come to resolution of this custody status issue once and for all. And I agree, it's either out or in. I think we're to that point. We've tried to slice that onion thin and it hasn't worked.
It just happened at one point.
Thanks.
Out-of-state offenses to addressing, what are we going to do about that? How do we make it easier?
That's kind of under criminal history.
Yeah, so we'll merge them together, but I'll put it close to it so we can specify that's like a key part of it.
I have lots of thoughts.
Yeah.
I don't know if, I think it might be in there, but like, I just think about, I said it a minute ago, there are these specific offenses with high departure rates. It feels, and so I think it might be somewhat represented up there, but like really diving into those specific offenses with high departure rates.
I think we had it kind of opposite of what you were saying. I think you were saying don't do it like structurally, do it for individual offenses, right? And so I think it's a different take on the departures here. So it's like review high departure rate offenses, or is that the right language?
Yeah.
As you all are thinking about other suggestions, I want to refer back to what the University of Minnesota researcher said earlier about thinking about the short and long-term research needs. So think big, guys. What do we want to do in the next, for the whole comprehensive review, not just in the next year?
Yeah, go ahead.
I think we should consider whether to say more about non-custodial dispositions, like rehabilitative, restorative justice.
So what's the right, like,
Trying to decide how to put that on a note
you're
card.
giving me a two. Is it like alternatives to-
Non-custodial dispositions,
That's a fancy way to like.
or what would be the better, alternative.
So basically, like, could there be more options than just probation or prison?
Yeah.
Could there be another type of disposition?
So non-custodial disposition.
I'm just curious how all this might relate to either crime rate, charging, convictions. You know, we talk about wanting to, minimize those on probation. Well, what if, crime rate's increasing and that's just a byproduct of that. And so I think through all this, we should understand what's happening, at least in our state, with the crime rate.
So it's sort of like review data on crime or something, or how do you word that?
Yeah, I don't know. But if we're looking at kind of broader,
Review
know,
crime trends or
So the collateral consequences of all this that we're talking about doing here.
yeah.
I'll put that review crime data, but help me reword that if you want. I'm looking back at my notes from the judicial presentation. So I had things like rewrite and reformat. Is that up here already? Sort of, maybe, is that the same thing as simplifying or is
Yeah.
it?
I think so, yeah.
Okay. Rank all offenses, which the chair raised. Have sentences cover wider range.
Well, that's within the box. So the presumptive sentencing box has a range, 15 below, 20 above, or 20 below, 15 above.
15 below.
Yeah,
So would that be a different, like,
that's a legislative change.
okay.
Is it written in a way where that's all we can do? I mean, we had to do that. Does it mean we couldn't go further on either end?
You're the judge, but I don't see any wiggle room.
There's such an overlap too, I mean, that's a consideration, how much overlap between the boxes.
And then I wrote down mandatory minimums. Is that?
Oh,
about-
yeah, that came up a lot.
Yeah, mandatory.
Yeah, referencing
Is
that.
it, is it about the because part of that is like, how is it referenced in the manual? Is
Yes.
that- okay.
Cross-reference mandatory minimum in the grids.
I think we heard two things, because I think there were some stakeholders that were like, make mandatories mandatory. So it's,
There's some that are mandatory, and some that
Right.
are.
Right, we
Yeah,
even
'cause we
have
have
mandatory.
Right,
Mandatory, which is the probation potentially, and mandatory, mandatory.
Fully right, so there was also the feedback that they all would, okay, so I'll put that as mandatory minimum, but there is, you're right, multiple things. And then my notes kind of ran out at the end, it was include something, there was one other final, on your final slide, there was one other idea that I didn't fully capture.
Oh, a grid or chart indicating when you can sentence concurrently versus consecutively.
Okay, so would that be a separate one, or is it?
That's separate, yeah.
So
And
it's concurrent
that's,
versus consecutive? And we've added a lot, which is good.
Can I just say one more?
Yeah.
One of the things that came out that I think is important is that if somebody is off grid and they have 6 or 7 criminal history points, somebody has 18, they're essentially getting the same sentence except for a 3-month differentiation. There seems to be some disparity in that. So in terms of like the grid, the grid that horizontal, I guess it's a horizontal grid on the criminal history points, I think we should look at how that functions. I guess maybe the functionality of 6 is this number and you get above 6 and everything after that you get 3 extra months, and it doesn't matter if you've got 18 points or you got 7 points. It doesn't make sense.
So can I put that as high criminal history scores, like how to handle
Points.
points?
how to handle, I think you're right, I think it's high criminal history
Yeah.
scores.
High,
It's like-
yeah.
But I don't know I don't know how that's defined, but I'm just saying it seems like if you're 7 and you've got 18 or you've got 23, what? It doesn't seem like they should be treated the same that way.
Yeah.
could that be as simple as looking at, instead of just saying 3-month addition, 10-month increase? I mean, is there a way to do a percentage based, based on the points?
We heard two ideas at least related to this. we heard some people wanted to expand the grid and just add more columns, I guess. Others wanted wider ranges within each column. So there was still some.
And that's what she was talking about, yeah. I recall when we were at the national conference and we had all those different, there was one grid that I found very interesting that had this little column over here. I don't know if it was Pennsylvania or if it was Oregon that had something specific related to those high criminal history people. So
I think that was the old Pennsylvania grid.
okay.
Yeah.
But anyways, I just think that's something to look at because it does seem like that is not, there's a lot of disparity in that, we should look at that.
I guess, yeah, I don't know whether this is something you can what we didn't hear directly was sort of general concerns about proportionality of sentencing relative to offense seriousness. We heard some specific examples that, you know, these crimes are being punished too severely, these crimes are not punished enough. So implicit in that, I guess, is a desire to have proportionality, which, like so many other things we've been talking about today, there's a tension. So on the example of high criminal history, we already have considerable overlap between the ranges on a row of the grid and the higher ranges above that. So if you're way out in the high criminal history, 6 or more points, you're recommended for a more severe sentence. That could be quite a ways up the grid if you have little or no criminal history. But it's capped to try to maintain some kind of proportionality. So anyway, it's just a tension between the sort of the intuition that says if you've got 20 points, you ought to be getting more severity than 7 points. But on the other hand, that means your sentence, recommended sentence, is even more disproportionate to the actual crime you're being sentenced for.
There's a version of proportionality that's like this existing one of like reviewing relative severity levels of the offenses. But I think you're also talking about, what I'm hearing is how the rows and the columns kind of interact.
Yeah. And how we balance proportionality of current offense severity with proportionality relative to criminal history.
Mm-hmm.
I think were the judges the only ones who brought up Hernandezing, or did anybody else bring that up?
The other practitioners also.
Probation did too, because that's a mess. Hernan,
It's a
D-I-Z. Yeah.
It's like Hernandez, but you ended in I-Z.
ING.
Yeah.
Okay,
We
we have a
definitely
lot
care about
here,
that.
but I will make a final call. Are there any other additions you can make?
Can I say something?
Nate's got some.
So one sort of thing that popped into my head as a result of this discussion kind of goes to your word lumpy, how some of these charges are lumpy, and I'm wondering if there's a way to unlump some of them so that, I'm thinking particularly of assault, you know, assault 5, assault 4, assault 2, where there's 3 different ways to commit assault, and one of them somebody gets hurt, and the other 2 nobody gets hurt, and but somebody gets scared, and I'm wondering if you know, that's something that could be done where the commission can kind of unlump those and sort of, I mean, I think if you were to do a sort of interview of people on the street, people would say, yes, it's worse to shoot somebody with a gun than it is to point a gun at somebody and say, I'm going to shoot you.
Unless you're on the other side of the gun.
I don't know. I think the person on the other side of the gun would rather not be shot. And I think.
I agree, Nate, but that doesn't diminish the threat.
I'm not suggesting it's not a crime. I'm suggesting it's less of a crime. And our current guidelines don't unlump that. And that might help some of the feedback that I heard that, you know, these are, that they're being treated disproportionately.
Well, it also goes to, you know, the dispositional, the departures. Because there is a lot of departures on those assault cases where there isn't harm. You know, it's
Right.
fear, it's fear assault, or it's, you know, there's no injury. Those are a lot of the downward departures.
That's why I think if we dug into those specific offenses with high departures, we'd figure out where that is. Like, and there might be something we could do differently with offenses and the way they're ranked to differentiate the appropriate sentence. Or there might be something we have to recommend to the legislature, just like depending on what we find offensive.
Does the worksheet include experiences of victimhood? Or when you're doing the PSI?
PSI includes victim.
Yeah.
It does. I mean, like, if I'm thinking about criminalized survivors, so let's say that they're being charged with a domestic, but they were actually a victim previously on someone else's charges. Like, would there be a way to note that history?
Yes, because at the same time that we do the PSI, we do the level of service case management inventory, which has those questions about previous victimhood for the client.
Would you add something either to the, like, is that part of the mechanisms for victim input or anything else you would add based on that?
I mean, I guess reviewing relative severity levels and thinking about sentencing for criminalized survivors.
Interesting.
So we kind of naturally grouped some of these together. And I want to, it probably is hard to read all of these, so we don't need to do all of them, but if there's anything that stands out to people who are close enough to read and where you can read my handwriting, is there anything people want to proactively merge? Otherwise, we will merge as we sort. But before we start, is there anything that people want to merge together that they can see on the wall?
The custody status is part of the criminal history score, so it should probably be up in that cluster by criminal history.
How about incarcerated low-risk offenders and non-custodial dispositions? Reduce number of people on probation that not custodial dispositions.
I think you could combine the unranked with the unlumped and the review relative severity.
So I'll do these, but people object, please also speak up. We can re-separate it.
You can say it.
All right,
So what about misdemeanors and juvenile, as part of criminal history? We didn't put those up there.
oh, should we, was this what the add you're saying? Or is this already there?
Misdemeanors and juvenile, going with the criminal history.
Oh, yeah.
Moving effective use of probation next to reduce number of people on probation.
These were actually, some of them look like they're clumped, but they're actually.
What group put up, or where did they come from for the reduced use of monetary penalties? Where did that come from?
Fine, that's mostly fines, I think, because we talked about an alternative being particularly having someone repay a victim. Sometimes that's more, I think that one was more fines related.
The treatment providers talked about fines.
Yeah, I think
Fine?
that's what that means.
That's what that means?
I think
Okay.
that, not as much, not
It
so much
also-
the restitution, because that a lot of, I mean, I've seen where victims want to be they'd rather have the person out working than in prison so they can get paid back.
Yeah, I don't know at this stage if we should say reduce,
No,
right? Like, because, I could see a scenario where certain offenders probably would be better served paying a fine.
So sort of explore the use of monetary.
So, I don't
think
know at
reduce
this
is the right,
stage
yeah.
that there's any agreement that it's just a reduce. It could go
Right.
both ways. I think that could probably work.
Is
for a
it
lot of
$50 the mandatory minimum that, so I don't know how you reduce it more than that.
Zero.
It's non-waivable.
Well,
Mm-hmm.
right. And I've had a similar, this is probably going too much in the weeds, but I had a similar reaction to reduce number of people on probation. I think that could go both ways, depending on what offense you're talking about, and what severity you're talking about. You might want to increase the number of people on probation for certain offenses.
I don't think it's the same thing, because I don't know what that means. Either you want them in prison or you don't want them in prison. So, and the non-custodial dispositions, I'm really interested to see what that means, because someone would have to monitor whatever that you're talking about to make sure that it's done. So it's just an interesting conversation with all those.
Yeah, so as we like move them over, if there's like a particular one you want me to put on top as like the best summary of like this cluster, right?
So the Hernandezing would go with the, in the criminal history pocket of stuff.
And, okay, so the next step, and we can keep merging and discussing what they mean as we do this, is to put them in these kind of lanes. So we want to think about what of these areas is most kind of clearly directly in the commission's scope. What would really be something that would require a recommendation to the legislature or potentially to other partners like Department of Corrections. And then what is clearly out of scope, meaning you don't even think you could make recommendations to partners or the legislature about that topic. There may also be another like category we want. Like there are some of these that might be more like, not things that the commission as a whole has to review, but that we can ask staff to do and bring back to you, right? So within this, it could be both things that are like require deep conversation and or things that just require staff action. But for now, let's put them together, and if you feel the need to separate them, we can. So I think maybe where we should start is what seems what was the operator the obvious one? Is there anything that seems really obvious of that it clearly is in one of those lanes of in scope would require legislation?
Criminal history score, Hernandez, honesty, misdemeanor, juvenile, like, this would be a
Cluster.
direct scope.
And unranked, ranking the unranked offenses.
Yeah, well, so, but does anyone, as I move this one over, if you have objections, feel free to voice them. I'll put the changes to criminal history score and all of the details underneath that there. And then I heard unranked and unlump. This is adjacent to the relative severity levels and the criminalized survivors. How, like, are we bringing this whole group together, or is it just part of that group?
They all pertain to the offense severity.
Yeah.
Okay. So it's gonna
The
move us
green
together.
one is probably the one that encapsulates the idea
Yeah.
most clearly to me.
So review relative severity levels with a lot of details.
Does the victim one fall in that? Like the victim, this one here, there's a fourth one on
Criminalized survivor.
victimization or
Criminalized
like a
survivors.
PSI. I was like, is that part of that?
I'll let you tell. You think this fits under relative severity or should it fit somewhere else?
I think it is in that, I guess where my head was at is if a victim has a history of being abused and then, as an example, fights back, and then when they get arrested, like they end up getting arrested because police show up and their partner is the one that has a mark. And then when they go to court, they end up getting sentenced for domestic. What I would love and what I was thinking about is that their victimhood is taken into account for sentencing.
So it would be departures, huh? Like under sentence departure area?
Yeah, would it be through a departure or would it be like in the grid or like what?
I'm gonna go with whatever you say, since it's day 2 for me.
Oh, well, I mean, if we're gonna, if looking at departures, and it seems like it fits into maybe.
The dispositional issue.
Disposition
Or defense.
or,
Something mitigating.
yeah, mitigating.
I'm thinking it's a mitigating.
Yeah.
So if we look at this group of revisit guidance and procedure for departures, concurrent versus consecutive, review high departure offenses, criminalized survivors, do those all still fit together?
I was just gonna add that, you know, like I agree that I'm not an expert on the state guidelines. I agree that I think it's probably a departure, but and I'm sorry, I keep talking about the federal guidelines, but the federal guidelines might have something like that in the offense level calculation. So it's really not that foreign to say that something like a mitigating offense characteristic could reduce the offense level or the offense severity. You could deal with it either way.
But so maybe this is not, maybe it's just like revisit departures, like it's a broader thing, because some of those, it's not, to the chair's point, it is necessarily about the guidance and procedures, it's also the individual cases or individual offenses that are high.
Commissioner Larkin has something to say.
Don't our guidelines provide as a basis for departure other mitigating circumstances that don't amount to a defense?
Yeah.
So doesn't that cover it? That's what we're talking about, right?
Maybe, maybe not. I mean, it kind of depends on the fact situation.
And also the offense, because
That
it's the offense.
seems
and
like
everything.
sort of a catch-all, that
So what was the term?
It may not be a defense, but
other mitigating circumstances that do not amount to a defense.
It's just a departure reason.
Departure
That's what
reason,
she's
yeah.
talking about.
Well, and the list is not exclusive anyway, so. But
it's not, but some people look at it as it is.
So I have that kind of revisit departures, including a bunch of specifics. What next? What can we place in group?
The mandatory minimum one up there feels like it goes in between us and the legislature. Because there's things we can do in our guidelines to solve some of the questions that came up. But if people really want to address the mandatory minimum themselves, which I'm not sure if I heard that.
That's not what the suggestion was merely, it would be nice if the grid cross-referenced any applicable mandatory minimum. And actually, one of the suggestions was if you'd actually just put the number there, so I don't have to open the other book.
That wasn't the only group that mentioned.
There was,
it, though.
yeah.
So we can also separate it, right? We could say like mandatory min in the manual. Yeah,
So it's like rewriting the,
right, and that could go with
I think it's already, it's already.
yeah, where did we lump all of the like simplification ones?
Changes to criminal history score.
Simplify.
But in my mind, it's kind of like this, right? It's like the simplification.
Clarify, simplify.
Yeah. So maybe that's, and then maybe we would have a different one if there were like broader changes to mandatory minimums. And that would fit under this lane. But so I moved over here, simplify guidelines and manual alongside how the mandatory minimums. In some ways, that's an intention because I think that, I mean, that looks simpler to reference all the mandatory minimums, but I think it would achieve the goal of simplicity, even if it adds some visual weight.
The wider range would be a legislative, that's a wider range of the grid boxes, wasn't that
Yes.
the one? So that would be in that second bucket.
So I'll read, so we have a large cluster here of decarcerate low-risk offenders, non-custodial dispositions, reduced number of people on probation, and effective use of probation. I think maybe non-custodial dispositions like plus probation is a way to summarize that. Is that fair? Like it's both, when are we using probation and when are we using non-custodial dispositions? And where does that sit?
Direct scoping.
Although you have to recommend to the legislature to get more resources.
That's a great point. So yeah, so maybe like we can add another one here, like resources for treatment services, or what, how do you word that?
All community supports, not just treatment, chemical bed, everything.
So like resources for community supports? Okay, we have expand training. Where does that fit?
Direct scope.
Review data on disparities and review crime data. We have design mechanisms for victim input.
Direct.
Folks agree with that?
Will,
I don't know what that
What does it
means,
say?
actually.
I don't know if that is direct.
Design, what does it say?
Design mechanisms for victim input. This was we were trying to take the feedback that there wasn't either at the case or system level enough victim input
That's the
was the
partners.
feedback. So we
Yes,
then,
for
That's a partner issue,
That's a
I
partner
think.
issue.
Yeah.
Yeah.
The court, whoever, judges.
Because there's a statute that dictates sort of how they're supposed to be engaged at the inception of the case, so.
okay. Kind of considering the proportionality of how offenses and criminal history score interact.
What's that first
What's the
word?
first word?
Proportionality.
Oh.
So and sorry, I went, yeah, I got kind of stopped in my right. So yeah, how do, considering how the offense severity and the criminal history score interact in their proportionality?
Correct.
Revisit the purposes and principles.
Direct.
Address rising presumptive incarceration rate and rising mitigated departures.
So it feels like two things on one for me.
Yeah. It's,
And I feel like we have the mitigated departure one already over there.
okay, what's the other one?
The other one is the rising presumptive prison rate, which is basically what the whole package of our policies leads to what the presumptive prison rate is. So in that sense, it's direct.
So I changed that one to address rising presumptive incarceration rate, and then knowing that the mitigated departures kind of fits in our other one.
There's the green one that says departures, yeah.
And then we have our last one, use of monetary penalties.
Partners.
I feel like that's outside.
That's part of
Well, years ago, the commission played around with a model pay fines idea.
it. Okay, so maybe it's the end of
And
training.
I don't think they ever got a district that agreed to pilot it. Kind of died.
Model D.
But it was something the commission worked on. It's a good idea, means-based or unit fines, state fines. And I mean, it's for the legislature probably to give the commission a mandate.
Gotcha, so it's kind of in this in-between space.
I guess I would say, again, in the federal guidelines, there is a grid for monetary penalties, just like there is for custody and everything else.
Okay.
Like the probation, et
So
cetera.
we're edging it a little bit closer back to.
I don't know if there's any statutory prohibition on us having a fine.
Nate said it's non-imprisonment sanctions. Maybe.
So I mean, we could do it, it's just not there right now.
So it's kind of inching back towards direct stuff, I guess.
Yeah, again, if you had guidelines for people for whom imprisonment is not proper, other sanctions, including day fines. Day fines are actually mentioned.
What are they called?
Day fines, so
DAY?
DAY, and I think the idea, Professor, and you can correct me if I'm wrong, is A day fine, the idea is that you get fined a number of days instead of a number of dollars. And so a defendant whose income is low will end up paying less than a defendant whose income is high, because it's basically a day's worth of wages for you, is how it works.
Or any other unit. So the same crime, two defendants get the same number of units, but the value of each unit depends on your disposable income. So Elon Musk pays a higher number of dollars than I do.
All right, so I'm going to read the ones we have and then welcome modifications to the wording. So we have changes to criminal history score and a lot of details underneath it. Revisit departures and a lot of details underneath it. Use of monetary penalties. Review relative severity levels with a lot of detail. Simplify guidelines and manual. Review data on disparities. Review crime data. Expand training. Non-custodial dispositions and probation, and kind of the use of when either might be used. Revisit purposes and principles. Proportionality of offenses the severity of offenses with criminal history and how those interact. And then address rising presumptive incarceration rate as the ones that are kind of within the commission scope. Then for recommendations to the legislature or others, design mechanisms for victim input, resources for community supports, widening the range, and larger changes to the mandatory minimums. Any like wordsmithing modifications? So remember, there is definitely a lot of overlap between these ideas. Again, I'll give the example that simplification could connect to a lot of other things, right? And that's okay. These are just kind of how we might frame the work ahead. So we're going to shift really soon into a break, but it's sort of a working break, at least for the beginning, in that we want you to use dots. And so, Chair Mitchell, remind, how long ago was it that this group last used dots?
It was probably 2019.
Okay. So a few years ago, some of you may have done this before, others not. So we're going to give each commissioner 4 dots. We ask that you use 3-ish or up to the 4 if you feel like you really need it to mark during the break. That I would focus on this set, the ones that are within the commission's direct scope, and I'll spread them out a little bit so that you're not all clumping here. And think about where do you have the most energy and what you believe would most benefit from further discussion and input from practitioners, the public, and the research team. So these are going to be things that will guide, we'll have conversations after the break about, okay, we selected this item, what do we want to learn, and who do we need to learn it from in order to guide our work? So again, it's where you feel the most energy and where you feel would most benefit from further discussion and input from practitioners, the public, and research. Yes.
So why wouldn't we put any dots in the middle?
You could, but I think they're almost like separate, right? Because I think ultimately, if whatever you do here might have implications here. So if you, like, what the outcome of the conversation on, where was the non-custodial dispositions, right? What you do here really impacts what you say about resources for community supports. So we could go here immediately, but where my head is, but feel free to push back, would be that we would kind of, you'd want to start here and then use where you go with this to inform what you do here. But if you feel like this is, one of these is really where you want to focus the commission's attention in the coming months, I think that's fair too.
Well, the only reason I asked that question is because I do think it's an interesting concept to widen the range of the box, because I think it does answer a lot of these questions over here. And that's clearly a legislative issue.
Yep.
And if we're going to do that, there's different work that needs to go into that piece of it that we can't do, but we have to do something to get it in front of the legislature or to the legislature. So I don't want that to get lost, and then we get to the end and we think we got to do that, and then we miss the opportunity to press that forward.
So that's a great point. So in my head, I was thinking these would sequence before this, but to your point, if there's things on this side that you think should be discussed first in order to then inform this side, then yes, go and use a dot on this side if that's the case for you.
So I'm holding a paper with 4 dots. Does that mean I can put all 4 on one? One on each 4 or 2?
Yeah, that's a great question.
Whenever you're hungry.
We discussed this, because it was, we had similar questions to each other. Our general recommendation is to spread them. However, we're keeping the autonomy with you. If you feel something is really important, you can use all 3 or 4 on one thing. But our recommended process would be 1 per thing. But we're not going to.
I also want to remind you all to make sure you all are taking the information that we gave you all from the public and the practitioners, as well as University of Minnesota researchers, because the next step is what we want to know more from the public. So the last thing I want to do personally is go back to the public and ask them something that we've already discussed with them in the conversations that we had from round 1 engagements. So
I'm going to move these over just to spread them out a little bit so that you're not all clustering. And yeah, but other questions about the process of did everyone get the dots?
Yes.
So basically, where do we have the most energy to address those issues, and which categories would benefit the most from further discussion?
And further input from the U of M team and us at MAD. We're not done yet, right? So we're going to go back and do more research. We're going to go back and do more input gathering. What are the topics that would benefit from input gathering and consultation?
We're putting those 2 together.
Yes. And we're not telling them how to research. All right, so Chair Mitchell, how long do we have for a break, or Nate, how long do we have? Probably like 10 to 15 minutes?
Yeah, it depends on how much time you think you want for the.
Afterwards, not too long. So maybe let's take a 12-minute break and come back at like 2:55.
Okay.
So during the break, either at the beginning or the end or in the middle, whenever you want, use your 3 to 4 dots, place them on the areas you feel most energy and that you feel would most benefit from further discussion and input. I'll leave these over here, but they are fair game if you like.
We will separately also vote on those. So I guess there's.
Not today. We will, I think, after you do those things, we will return to this and say, are there other things we need to add based on the work you've done on those?
But we're not going to
Not
separately talk.
Not today. Right, go ahead and go. All right, so we are back, everyone. So we're going to talk about the results from the dot voting, and then we will kind of segue into thinking about how we're going to learn more of these topics in the coming months. So Shamsa has the results.
Drum roll, please. All right, so review relative severity levels got 10 votes. Simplified guidelines and manual has 9 votes. Changes to criminal history score has 8 votes. Revisit guidance and procedure. Is that crossed out on purpose?
Yeah.
Okay, revisit departures has 6 votes. Review data on disparities has 4 votes. Non-custodial dispositions and probation has 3 votes. Popularity offense history has 2 votes. Addressing rising presumptive incarceration rate has 1 vote, and expanding training has 1 vote.
And just a note that some of these expanding training can still happen. It doesn't necessarily need to be a focus of the commission's meetings in the months ahead. But so this is really how are we focusing our collective input gathering? But a lot of these that are in that middle space could still absolutely happen. But yeah, Nick, you want to add something?
Yeah, if I could just make a comment, one of the budget items that the commission is requesting that we talked about last month is requesting a support person, a full-time office and administrative specialist to senior. And one of the intents of that is to free up Linda to really focus on a more intensive training program. Because right now she's having to do a lot of that office management. So we are in fact trying to do that.
All right, so as we turn into this final item of discussing, for Matt's part of the day, of discussing how to learn more about these topics in the coming months, we first want to have a broad conversation of where we are in the work and kind of the audiences we know we haven't heard from and get your direction there. And then we'll turn to these specific areas, the top probably two-ish, depending on time, and talk about what specifically do you have for us in terms of research questions and who do you think we need to hear from. So just on the overall front, wanted to note kind of where we are in that timeline. So we're now turning to that follow-up engagement kind of segment of the meeting, where Matt will be conducting follow-up workshops or other activities based on your input. And in parallel, of course, the U of M will continue its research work as well. And then on Matt's end, we'll be completing a final report in spring of 2025. So before we talk about the specific topics, which is on the slide, we did want to note that there's been good conversation today about some of the broader audiences across all of these topics we haven't heard as much as we want from. So there's been a discussion around Hennepin and Ramsey County particularly on the prosecutor and defense side of what are we missing there. I also want to note that originally we had intended to reach more members of the kind of general public who didn't have any connection to the criminal justice system. We have not heard from them as part of this process. Just want to open it up.
As well as the folks who are currently incarcerated as well, so.
Right. So I just want to open it up to, are there broad audiences or specific audiences separate from the topics that you want us to consider how we could hear from?
Madam Chair, if I may, just a couple of audiences that I think may have been discussed in the past. One is we've gotten a lot of input from academics from a research side, but not really sort of opening it up to them to say, what do you think is wrong with the sentencing guidelines and what should be changed? So I think rather than, in addition to relying on them for their outstanding research capacity, maybe just relying on them for their opinions, their informed opinions on that. And I base that on Pennsylvania's experience where their process got delayed because they didn't initially reach out to academics. So that ended up being an important thing later on. And the other is, I think you mentioned MSGC staff before, but we stand by and continue to be willing to discuss this if you want.
Thanks, Nate.
Kind of a Pandora's box. Do we want to, sometimes we do, sometimes we don't. Do we want to consult with or ask for input from the legislative committees that deal with these? They may or may not give us feedback. We can send them a survey. They're all campaigning. Well, the House campaigning, Senate may be more interested. We work with them. Nate's over there talking to them. Might be helpful to see what they might be thinking.
Other audiences or any reaction to that or others?
I would actually echo that, and we've had some public hearings where folks in the legislature have come to commented and gave public comment. And I think if we engage them now, and if something comes before them, they've had an opportunity to participate in the process, I think it gives due consideration to whatever they might see as part of that. And so I like that idea of reaching out and making that offer, whether or not anybody does participate or not. I think that's a different issue, but I think we should take the ask.
Especially since they're funding us, we're going to go back over there and ask for some more funding.
Well, we may be even asking them to make some changes based on some recommendations that come from us as well. And so again, if they're part of the process, I think that earlier engagement sometimes is better buy-in.
Thanks. Any other general feedback on audiences we haven't heard from or should hear more from?
Or partners you all should collaborate with as part of the comprehensive review.
I just have like one sort of overarching comment. Like, I actually do agree that some of these groups are, that we've talked about, the staff, the Hennepin Ramsey legislative, committee members, it's really important. It would be really important to go back to them as soon as possible to make sure that they're included in this feedback stage. But I also have a view that I don't want to spend a lot more time on that piece because I think we have some really good directions. And to me, like, the more important part would be to get to work and then get feedback on some of those ideas as we go. But I think there's some really critical people that were missed in this round, so we kind of have to do a little bit of both.
That's exactly what I was thinking, Madam Chair. I feel like we know the work that needs to be done, and it has to happen in this room, and we just have to make some hard decisions. Yeah. I don't know how much effort, I think it's important to talk to Hennepin and Ramsey County since they're the biggest counties and they didn't participate. But other than that, I don't know that we need to go out and try to get new information. I think we have a pretty good representation of what people think here, and we just need to get going work.
And so maybe what the chair was getting to is maybe there's a way to, as we do that follow-up engagement on these topics, we prioritize and focus on some of the audiences we know we didn't hear enough from in the first round. So like, we're not asking the general questions again, but instead, as we ask the more specific questions, we're making sure we hear from Hennepin and Ramsey County, for example.
There's a difference there. So, okay, yes,
Yeah.
like I think that's true about like Hennepin and Ramsey, but I actually didn't think about our legislative partners as a stakeholder, and I don't know why. But it would be probably good to ask them the general questions and see if they come back with something we didn't think about. I just be curious.
Other feedback on?
The other group that's coming to mind is family members of victims.
I know in our recruitment, some of the organizations kind of reached both. I don't know, Shamsa, if you want to add anything to that.
Yeah, but then there's always more room for more.
Yeah. All right, so welcome continued feedback on this. I want to turn us though to the specific ones you were ranking. So we'll start with the severity levels. So as we kind of turn to that as one of the topics to focus in on, we want to know, what do we need to learn about severity levels or about that broader topic to inform potential changes to the sentencing guidelines? So what are we trying to learn from the public, from practitioners, from the research that would inform how you review relative severity levels?
I don't mean to do this, but it's just like, that's something we do all the time, and we do it through the commission staff, and it's something I'm not viewing that as something where we need to go out and talk to the public or anyone else. It seems that that's at the core of what we do every year.
So it's kind of an
It's just a
existing
matter
process.
of saying, and I think the commission can tell us this, okay, where are the high departures, which offenses? It's a matter of taking a look at rankings we have that might be out of whack or disproportionate to others, and thinking of ways to re-rank them. I don't know that requires a lot of outside research to do.
My question for that is, what's the difference between the report the commission puts out every year versus the comprehensive review then?
Well, I could see another really fun exercise. I mean, so if any of you have ever read the book on how the guidelines were created in the first place, the original commission literally had every offense on a card, and they had to shuffle them together like a deck. And I'll do it individually and then see how that played out amongst members. Like, we could literally do that exercise again and see where things end up and see if we would change things, thinking about offenses. And we haven't done that in 40 years. So.
And you could do it,
Just saying.
or you could ask others to do it, right? It could be something that you
Yeah.
ask practitioners or the public to do as well, to see how the public or practitioners think about severity compared to others. Thanks.
I have more of a procedural question, and it relates to, our time is limited and our energy, and so is yours. How would you actually, I mean, supposing you wanted to know what does each constituency or audience think about the current severity level rankings and the things that are in them, or the common things that are in them. How would you actually, would you have more meetings, or would it be a survey, or how would you actually collect more information?
Yeah, I think there's lots of ways we could approach it. There's the like physical card sort. There's also, you could do like an online ranking where you could have sampled the offenses and gave people a constrained list or the full list. Today, though, I think I really want to focus your attention on what are we asking, because I think then we can come back with different options for method. But I think the options for method are really dependent on what you want to know. So I guess the question is that what you want to know? Do you want to know, and who do you want to hear from? So that's the who part, right? Is it this room that you need to kind of assess each other's ranking of severity, or do you need certain practitioners or certain segments of the public to weigh into who do you need to hear from as you're doing that?
And then just to follow up, I guess I agree with Commissioner Larkin, the ranking offenses is what we do, and we, some of us more than others, have a sense of what a typical case is, which is the whole fundamental concept in severity ranking, and some of these constituencies have no idea of that. So, our assessment of that is better. And I guess, on the other hand, judges certainly have informed views about that, but their departures are, in a sense, the place where they're voting a little differently. So we have that too.
There was a statement made by one of the, I believe it was one of the prosecutors in sessions that said, we as a whole need to reassess, not just the autonomous body. So thinking about what the public's members have said, including the practitioners within these sessions.
Or it's like, where is the place where their input really would inform you, right? Like, from the data what the departure rates are, but where is there uncertainty in your mind that could be resolved with more input? Like, what is unknown from the data?
I guess when we were talking about where to put those things, and I said that victim input went under our scope, part of what I was thinking about is, would we be getting, or I guess I would advocate that we get victim feedback about what it is that we are talking about and where we land potentially. Because, like, thinking about, if we go back to some of the cases that we were talking about, where somebody might engage in a domestic and engage in a drug offense, and a drug offense is what ends up being looked at and the domestic doesn't. If a victim survivor is looking at that case, they're gonna have a lot to say about it, right? And this is an opportunity, if we're going to be doing such a depthful analysis, to be able to have somebody from the outside who is the person that's impacted by the decisions that we're making, be able to give us input around what that impact might be for them before we actually roll something out and have it be the thing that we use for the next 40 years.
Well, that's why I'm kind of wondering, so to me, because I feel like we actually did get some really strong signals from the feedback that we got. Like, we got feedback about drug crimes versus person crimes. We've gotten feedback about criminal vehicular homicide not being at the right spot, ranked at the right spot. Like, we have gotten feedback along the way. So to me, what I'd like to do is like take a run at re-ranking and then get the feedback on where it might come from. Like, what do people think of this? What did we do wrong? What else do we have to consider? What are we not thinking of, to then refine any recommendation?
And I feel the same. I feel like people call in at the end of the hearings, a public comment period, and say, are you people out of your minds? The judges are telling me my son is dead from a drunk driver and it's only worth this many months. That needs to change. And so and I appreciate the work you've done, it's very helpful. I just don't know that we need more information to tackle this.
To tackle
We need
that
to
one.
tackle it, and what you're talking like sort of a straw man public hearing, or we then do a public hearing and we hear from the public, and we often change our positions based on those public hearings. So I don't know that, I'm not feeling like I need more information from stakeholder groups at this point to go forward. I don't know that you're gonna get it from Hennepin County. I think folks are probably well aware of what we're doing and their opportunity to weigh in and chose not to.
So here it's partially a sequencing thing of you want to give people more to react to before you seek more input. You kind of want to try.
Yeah, there's nothing that we're gonna do that I don't want broadly put out there. So like after we make some changes or make some recommendations, I want that broadly put out there, and I want broad feedback, and I, maybe not even the public hearing, but like that I could really see Matt, like that's your role, is to get it out to groups to help us get feedback on what we've done, so we can react and refine before we send it in. So there's nothing that we would do that I wouldn't want that for. But I think that this would be like an example of something where it's like, all right, we got this one. We can start work on this without more information. There might be other things on this list that that's not true about.
I do want to turn to some other ones then. Before I do, any final comments on severity levels or what you'd be hoping to learn from the public or practitioners or research?
What did you just ask? I'm sorry.
Oh, any final comments on this, on severity levels? So then I'll turn, if not, then I'll turn to the simplification. So simplifying the guidelines and the manual. What would you?
Well, I'm sorry.
Oh, yeah.
I mean, I think any kind of changes we want, we need the data. What are the departures? What are they lumped together offenses that need to be segregated out, and then we need to adjust the severity levels? So anything, I guess, related to how did they get? What are the commonalities of those offenses at each severity level? What's a person crime? What's a property crime? What's a nonviolent crime?
But isn't that the sort of data we get from our folks all
Yeah,
the time? I mean, I'm not
what-
saying we don't need data, I'm just
Yeah,
saying I don't know
whatever
that we
else-
need to talk to
yeah.
stakeholder groups in the
Oh,
public
no,
to
not
get
stakeholder,
that.
no, I thought you were talking about.
No, they're just asking in terms of going out to talk to the people they've surveyed about rankings.
Oh,
Well, and it could be, or it could be saying we want the U of M to do
weigh in.
more, to get more data, to get more. But let's turn for a bit to the simplification. So what do you feel like you don't know that you would need to learn to inform your work on simplification?
I could write a draft for you if I wasn't looking at 5 opinions on my desk. That's just, I think anybody who's in the room who works with the guidelines could talk about different, organizational formats, headers, how to set it up, more of a rule format, statutory format. I think people just look at the guidelines and there's so many columns of print that it's overwhelming, and as somebody said, it's all in there, you just need to read through so much to find it. There are ways we could probably break it up, but
So
I don't know that we get that from stakeholder groups.
is there a single obvious path in your mind of simplification, or would it be like we need to, do a focus group of probation and corrections practitioners and say like here, different styles, right? Like where is there uncertainty of what simplification would look like, or is it very obvious to the group?
I don't think we'll get those answers by doing more focus groups. I think they need to come from within this body who is, we're blessed to have these additional resources, but there are plenty of, other groups like Supreme Court rulemaking committees who did their own rewrites, and they didn't have any outside help. So I mean, part of this group is picking people with experience and expertise who can do some of that work. And I think in terms of simplification and reorganization, this is one that falls uniquely to those of us in the room.
What do others think? Do we agree, disagree?
There's also an element of the final drafter should be somebody who is skilled in plain language.
Right.
And that, so whatever we get
And
to.
respectfully, that is not individuals in this room.
Correct, I know, that's what I was thinking, we have a handbook for incarcerated people at DOC, and it is awful in terms of understandability, so we just hired somebody whose skill is plain language, and that's, the goal is to get that document into a plain language format, so as we go on, that might be one of the ways we need to spend our money, is to have somebody with that skill
But that doesn't,
take a run at drafting too.
that's not the result of research.
No, I agree.
Information gathering. That's
I
a
agree.
whole nother skill set.
Yeah.
As an editor.
I guess one of the questions I have is, as part of this simplifying and making it less complex, isn't that gonna also take into account some of the things that we may be revising or eliminating or changing? So that it seems that that is actually a step that would come after we do some of the other more focused.
Right, you wouldn't want to do that first and then have it be outdated before it's ever
Right.
published.
Because if we're starting with trying to rewrite it right now, we haven't dealt with some of these other messy parts of it.
Okay. So then let's turn to the next one, which is criminal history score. What do you need to learn to inform potential changes to the guidelines there?
I feel like this is one where the U of M research team has a big role to play. Because I think we probably have to put some ideas on the table for what are we thinking about, or they may have ideas to put on the table for us. And then we need some analysis done. I think our staff would be involved in that too.
One thing that I think might be helpful is to look at the other states that have guidelines, how they treat, like, for instance, if we're gonna go topic-wise, the out-of-state convictions, how they look at them, how the federal guidelines look at them. I don't know if that's something that you would look at as a research group. That seems like that would give us a comparison or some ideas on how to deal with those. That makes it, better for our system.
That's a great example. Other examples like that of what you'd want state comparison on, or examples from other systems? You mentioned the federal system a lot,
Some
but
of the other states that are guideline states.
How are others feeling in this room?
it feels like there's a lot of things that you all want to do as a body, right? So that's the reviewing the severity levels, eventually simplifying the guidelines and manual. There are some things on the other end of the spectrum that seem like there's things that staff can lead, like expanding training. Where are you wondering, like if we go back to Hennepin and Ramsey, or go back in general to the people that we worked with and talked with and others, what do you need to know? Like really broadly, if you look at the departures, if you look at disparities, if you look at the non-custodial dispositions, like where is there a need to get more input? Or is it really just that you need to do some work to bring to people?
And does everyone agree on that?
To me, that sounds right, so that's just my opinion.
I think we need to do some work.
Yeah, exactly.
Because I think I hate to get fault, but it always seems like to come down to the end. Well, here's the idea. I think we need to start generating some ideas And a lot of these things we've debated and discussed before, and we need to come at it with sort of a new global perspective. And that's the value of the comprehensive review. We're not just arguing about half point. We're not just arguing about, because it's like, all right, all of these things now are at play. You know, if we're gonna, you know, shave off misdemeanors and juveniles, but we're gonna raise something over here, we're gonna re-rank something else. I think we need to put some things on the table and see what's palatable to the group. And then maybe there could be sort of a sharing of that at that point with stakeholders to see, sort of take the temperature.
Also looking back at the list of audiences we were talking about in terms of academics, like if we were going to academics, is that asking the same questions you were asking of staff, or what would we want to do? What would we want to learn from academics, for example?
I guess for me, I would want to know what the disparities are. And I like the idea of creating something and then going back to the community and asking for their feedback. And the same groups that you all met with before. And based off of feedback you've already gotten, like what seems to be the problem areas with the guidelines, and be able to get more data, like more detailed data about those problem areas.
Yeah, I would agree with the chair and Judge Larkin as well. I think that if we could cobble together some sort of draft and get circulating that, so we could start sort of working from that and get the nuances from those various stakeholders about things that we're working on. I just feel like more feedback is probably gonna just give us more of what we already know, and I think we need to roll up our sleeves and start getting at something to put pen to paper and get a draft circulating back amongst those groups. So my silence isn't because I'm not in agreement, I'm just sort of repeating what everybody else has already said.
Is it true for others too, or is there other thoughts on people's minds? Yeah.
On the academics, I don't know, I guess it's particularly for academics in Minnesota, but I guess Minnesota guidelines are pretty well known to criminal justice academics outside of Minnesota. And even outside of Minnesota, something that's discussed in class and seminars. And I guess rather than wait and get blasted by a lot of them for, don't you realize the worst thing about the guidelines is X, and you haven't really given enough attention to that. You just get a little reading of that. I guess with the risk, of course, you be careful what you ask for. But I am happy to confess I'm not in communication with a broad circle of academics. I just assume that they have some views about, guidelines generally, our guidelines in particular, our guidelines compared to other systems, and ours is better. Why is it better? Or what's good and bad? I think they will have views, and it could be something we haven't thought of, or at least haven't mentioned.
I mean, we do have our academics sitting right here.
Well, and here.
So I think there's probably some groundwork we can lay in terms of making sure that when there is more to share, that we make sure we built the connections and relationships in Hennepin and Ramsey to make sure we're hearing the feedback in other kind of audiences too. Maybe some side pieces of like the legislative committees, and maybe something that the chair or vice chair would want to do that probably wouldn't be a mad engagement. But I'm hearing broadly, you all want to do more work to bring back to folks. But any other, yeah.
Yes, so if I can just make an observation about where we are fiscally, and I'm sorry if I seem obsessed by that, but so right now MAD is on a contract, and their contract expires in less than 9 months. And so what they're asking for now is what's the next thing we can do that would be helpful to you, the commission, that we can write up in our final report prior to our expiration date. And we have no idea what the fiscal picture of the legislature is going to be next year and whether they're going to have any money for it. We might be on our own for the second phase, and it might go a lot longer than 4 years by the time we're done. But we've got MAD right now. So my thought is respectfully, Commissioner Ladd, maybe instead of putting pen to paper, we just kind of come up with some broad ideas, not necessarily ideas that capture a consensus or even a majority, but just ideas that the commission thinks is interesting. And take those ideas and think, or maybe it's ideas that one stakeholder group came up with that another stakeholder group was silent on, and just say, hey, here's an idea. What do you think about this? And kind of get a little, because it sounds like from the chair, that's kind of what would be most valuable to you is sort of input on what do you think about X, right? And the question, what do you think about X, is really sort of that's what we're budgeting for. That's what our budget request is for, is we have another contract with MAD in the next biennium. And that's the research question. What do you think about these policy changes? And the idea was that those would be policy changes that the commission is seriously considering. But maybe at this stage, it would be asking too much to kind of, for the commission to coalesce around some actual policy changes, but maybe just some interesting ideas would be a better way to put it. If somebody's throwing out the idea, what would you think if we got rid of misdemeanor, juvenile, and custody status? I think somebody threw out, just or ideas like that. And what would you think if we did a top to bottom card deck re-ranking of all the offenses, or just some of these concepts that are, and what should we consider in doing that? I guess that might be a suggestion. I'm honestly just trying to think of how we can use MAD the best in the limited time that we have.
So we're not on an hourly rate, is what you said. We paid for this service, so we may as well use it.
Well, there is a contract rate, but if they go over, we'll be okay, I think. So, I mean.
Well, it's more that you probably can't reuse the funds later, right? So it's,
yeah. Right. So yeah, the funds will all go away at the end of June. So whether we've used them or not, and they won't be lost. They'll go back into the treasury. But so I guess that would be my question. Maybe to reframe your question, if it's not maybe more specific questions along those lines, are there some policy ideas that you want to bounce off of these stakeholder groups?
And I'm feeling it's kind of late in the afternoon too, so maybe it's not something we can harvest all of those now, but maybe that's the question to kind of leave you with. And then you would then give us direction, in November or something of what are those ideas, interesting ideas, to use Nate's language, that we go back to practitioner and public groups for a reaction to. But if you have interesting ideas right now, feel free to voice them, but I don't want to limit it to what we can think of late in the afternoon.
I'll just say that one thing I struggle with is I agree with Commissioner Larkin that where we are now is we need to think locally. And so getting feedback on a particular policy idea doesn't really help us, because that's how we've been doing our work all along, and that's why we've gotten stuck. So it's to me, it's what are the 10 policy changes that together make up our big idea? Because I think that's the only way we're gonna actually move forward. If we agree these 10 things change and we agree that they balance things out and get at a lot of different things that we're trying to deal with, rather than one change at a time. I think we're to that point where pull on a thread and it unravels a whole lot of other things, and that's where we get mired and stuck and we can't move forward. And that's why custody status is the bane of our existence. For those of you who are here through all of that. That's just my feedback. I feel like we need the big global overview. And I think I might have cut you off, so I apologize.
I was just gonna clarify, what MAD does is take our questions and go back to community and do the listening sessions. And the U of M is looking at the database type data. Okay. I just wanted to clarify.
Great question.
Maybe
So
we
we
should
probably
start
should,
with that.
yeah. Probably should pause here because I think we kind of reached where we can today, but really grateful for giving us such a long period of your day and having really rich conversations and kind of letting us bring voices of our sessions back to you. But yeah, we can keep the conversation going on when is the right timing to return to get more stakeholder input.
And we did say this was not gonna be easy, so welcome the tension.
I think we'll kind of hand back the gavel metaphorically to the regular order of the meeting.
Well, thank you. Like, I actually, this was fantastic. Like, I didn't expect to come out of this meeting with some really clear ideas of where we wanted to do work, and I feel like we did exactly that. So I really want to thank you for the facilitation that you did today. It was really fantastic. I want to thank all the commission members for their input. We do have always at the end of our commission meeting, public input. So if there's anyone present who would like to provide input to the commission, that would be that. Mr. Thomas, go ahead.
Madam Chair,
Just if you would just say who you are and then go.
Sure. Madam Chair and Commissioners, I'm David Zimmer. I'm a policy fellow with the Center of the American Experiment. I want to thank you for allowing me to be an observer and a citizen observer. And thank you for the really important work you guys are doing in this project. Just a couple of thoughts come to mind as I was listening today. I always fall back to what your statutory mandate is. And I know some of you have heard me say this before, not trying to preach, but I think as you consider modifying the guidelines, you always have to fall back on what is your primary consideration. Your primary consideration is public safety. Doesn't mean it's your only consideration, but by statute, your primary consideration is public safety. I also realize that's open to interpretation. It doesn't mean incarceration is the only way to achieve public safety. But I get a little concerned when I see some of the priorities identified are changes to the criminal history score, changes to severity level. I'll tell you that the general public is shocked. Well, let me say it this way. The general public does not feel that our sentencing guidelines are overly punitive. And they are shocked when you show a member of the general public the presumptive line in our sentencing guidelines. They are just shocked. They're floored that it takes X number of residential burglaries before you're even presumptively going to prison, or auto thefts, or you name it, you name the crime. So I'll cut my comment short. I just want you to keep in mind what the general public feels about this. And I know the facilitators were mentioning that maybe the general public needs a voice in this too. And I don't know if you've considered using a pollster or something, but that might be an effective way to just get the general public's view on the work that you're doing, as opposed to somebody like me who stands up at the end, or somebody that calls in at the end of these meetings, that they're probably not representing a broad range of the public. So something to consider. Thank you.
Thank you for your comments. Anyone else that's present today that wants to make a comment? All right, did you want to say something? Oh, okay. All right, well, then I think we have more than done our work today. There's nothing I'm missing, right?
No.
All right, well, thank you everyone for the robust conversation today and all of the participation. I really appreciate it. Unless there's any objection, I will adjourn the meeting and we will see you next month.
Thank you. No objection.